it'll bring up a context menu as well, but you don't need to worry about that, or you can wheel up and down with the mouse there as well.
Right.
All right.
That's fine. Thank you very much.
No bother. I'm sure I'll go back to the start of it there.
That's fine. Thank you. Nice and easy when you're first.
Yeah, it's nice and easy until you stand up there.
Yes.
Nice to see you.
Exam boards that I've been.
Indeed. Nice to see you. Can I recognise when I saw you from here? Good to see you. Welcome.
Delighted to be back. Always a pleasure to come here.
Good. I missed your dinner last night. I said, oh my God, was Tim Anthony supposed to join me? He said, will you be home? I said, quiet. I have to text my wife saying, I'll be home, so make sure you come. You enjoyed it last night.
It was a very good dinner. Excellent company. I thoroughly enjoyed all that.
Good.
And I have the good fortune that the plane home isn't until tomorrow afternoon, so I get.
And I work in birds. You probably never know that because we normally am in much more formal. So my work is on birds actually.
Is it good?
I'm an ornithologist, and I have people working. You work in? I saw nearby or something. Work in Scotland and enforcement, is it?
Yep. Yes. I've just taken that. I've just taken that on. So
Birds of prey would be a fine feature in there, I'd say.
birds of prey would be a big thing with also I think up to 14 just found poisoned in one patch. So that's
Are they carriers or?
red kites and buzzards. I don't know what
Because I wasn't hearing, but the guy was conversation with them. Similar issue, wasn't it? Two carriers that found posted in there.
yeah.
Were they were placed there, or were they?
Yes, there's all the dead ones are found on the borders of the states across.
So it's an interesting challenge, isn't it?
Yes. I've just got involved in the partnership against wildlife crimes. So
Okay.
it makes life interesting doing with the government and the gamekeepers and the.
Oh, it's good, isn't it?
It is interesting. It's still you cover anything. Well, it took from before Christmas till the middle of February to arrange it. And that was arranged at 4 days' notice because the main executives meeting at a certain time. And so
parliamentary questions coming, they needed to deal with. Yeah.
just awful.
I don't know, with no idea how many people here of course.
No idea coming here, and I don't. This note was here saying, please not resume at 2:30. So
I think Owen said just to give a bit extra time. I think what happened was one of the sessions.
one of the sessions must have run on because we finished early and they weren't even ready for us at lunch. So
Yeah, I think that's what happened. So I think you have a bit of time. I'll let you focus there. You probably want to get yourself organised.
better be sure you're behind the right label.
Oh yeah.
Or move the labels.
Actually, I'm going to go for that side. That is the most appropriate place to stand. I'm a professor of zoology here. That's my I work at.
And what aspect of birds are you?
A whole range. I mean, I do. We've done actually a big project on turbines and hen harriers at home, which is an interesting problem, as you probably know.
Yep.
And from ecology right through to life problems, you know.
Yep.
So I've actually 40 PhDs so far.
Very good.
So it's all good clean fun, as I say. Stocks is just left to take the post in Scotland. For BTO, British Vice President, British Trust for Ornithology as well.
Yes, my wife did a lot of work for the Bird Atlas.
Oh, actually, really? It's a good job, isn't it? It's just stunning, isn't it?
And the IT and the systems that ran it was so good and efficient.
Unbelievable.
Wonderful. Just
Better than I've ever seen anything.
yeah, I mean it was just every time, you know, and I kept saying just how excited he was, how well it was running. Hello, I'm
Rachel Minch.
I'm Colin Reid. Nice to meet you. your presentation's on the...
It's on there.
It's on the
isn't it?
sheet, yeah.
Phew, that's the main thing. I don't remember what I'm going to say.
That's right, print it out
Looking
beforehand.
at it from a legal aspect, very much.
Yes, pure. I'm sorry, purely legal.
You're
Yeah.
legal. Perfect. I've been here since yesterday.
Yes. Still surviving, still looking reasonably happy?
Oh, Jesus. Well, yeah, I'm looking crowded. This is going pretty good. We haven't, nobody died yet, you know. But,
That's a challenge for the afternoon, isn't it?
that's a chance for the afternoon. That could all happen, yeah. But I was hardly chatting to you at all last night. You were
Yeah,
hemmed
no,
in.
it's alright. I was very well looked after, very enjoying myself.
Was it a nice evening?
Yeah, very good.
It's nice to get people together actually because we don't get that many opportunities.
I was saying to him, I recognise Colin from the lower board actually. When I came in, I said, "Did Colin be there for the exam board?"
Ah, that's right, of course.
I was saying I was embarrassed last night. I should have been there, and it's only when I said we didn't see you. I said,
I assumed you got caught up.
no, I never.
I was just saying because John's a bird.
Yeah, we're just talking about birds.
Ah, right, but I was explaining that the standard work on this in the UK is your third edition now, isn't it?
Yeah.
Yeah. And
Now it's a date.
but that's this area's moving, isn't it?
Yeah.
You know? I find myself even doing the lectures on the area, going back to the 97 regulations here and stuff because it's just changed from 2005 to 2011. It's just, you know,
So much detail, so it's just hard to keep up.
services here. An interesting area too, isn't it?
Very, very much so. Trying to the whole payment for ecosystem services issue. We need some.
I have a master's thesis at the moment looking at forest ecosystem services.
Foresters are very.
They're engaged enough.
They're very engaged. I spoke at the Institute of Chartered Foresters conference last spring. Remarkably forward thinking and keen to explore different ways of looking at things compared to some people, and very much.
That's because they came to the party early insofar as the carbon sinking capacity of trees might have been on the agenda.
There's that, and also because trees don't generate that much income.
Yeah.
Anything that does it, they're keen to capture it, and it's interesting. There's people talking about somewhere near in North Wales, and what they can do. A lot of people want to use the bike trails and so on, but people won't pay for that. They won't pay to come to just into the countryside. What they will pay for is car parking, and what they really will pay for is oatmeal cakes. So you're using, and there's an estate that's got a big. A lot that's used, a lot of lake that's used as a part of water, feeds into the water supply, and it's got a lot of biking tracks and so on. But what they actually make money from is car park and as you say, it's a property. How do you get people to?
One of the areas I'm concerned is the extent to which habitat provision by forests, for example, how do you value that? We can use.
And in the payment for ecosystem services, you get paid for that separate different carbon sinking.
Can I just say, John, for chairing, because we've got panel sessions, I've asked the chair, really tight, because people go between.
Yeah.
But the other thing is to take questions after each speaker, so that we keep everybody, somebody's total commitment is
We will
within
speak for
those.
20 minutes, Colin, or what's your...
I'm hoping to keep it down to 20 minutes.
That's okay.
Yeah,
But I mean, so what it means is your envelope is 30
Yeah.
minutes,
So that's for each individual, so that people can then, they don't have to wait for a question, they can go to another session.
Okay, perfect. Go on, make sure that's done.
And we'll run from 1:30. We said 1:30 because we were 15 minutes late over.
Didn't say that.
Were you in the Marine?
I was really.
The Marine were gone. I was just everybody else was late. And I was thinking, there's the ship's clock. The Mariners bang on time.
Rachel now.
There isn't, but you can take this. And I'll leave that down. I'm ahead of you with my dinner. I'll bring that down on top of the I'll leave it up.
Rachel, can I ask you where you're a graduate from, if you don't mind me asking, to say a few more words? Where did you graduate from? Cambridge.
Yeah.
Heard of it?
You got the most succinct bio, so I...
Well, I know.
Yes, mine was on the shelf.
That's all right.
Cut it down, please. It was just.
I know exactly the reason.
Anything else I wonder? No,
Are you a Cambridge man? Or was your answer once when I asked you not to Cambridge? Both.
Both, I'm afraid. Yeah.
Which?
I love that answer. UK for a long time, but I stopped.
In Ireland?
Yeah, I stopped doing that just in December.
Oh, they do.
Maybe something.
Okay, no, that's great.
I get wheeled out occasionally for recruitment purposes and so on. When you want to impress some parents, having
I'll have to ask you, I'm very interesting and exotic about yourselves that you haven't told anybody else that you want me to say about you. No?
I like printmaking.
Like which?
I love printmaking on the side.
Printmaking. Okay, good.
I don't need to say.
Of course I will. I make pizzas, that's alright. Catch long.
Heavy metal.
Owen, I need to know something about you. Come on. Something unusual and different.
There's nothing unusual about me.
There is.
Nothing to admit to anyway.
Are you rock and roll? Do you play music? Do you play?
No, I don't.
Do you sing? Do you
I used to
dance?
sing years ago, but that's a long time back. Jesus, John, there's nothing to say. I'm embarrassed.
You'll make somebody else. That's dangerous.
Colin, have you read anything interesting?
Make me more interesting than I am, please.
Still play hockey and cricket.
Well done.
Carrying an injury just now, but I can hold the lap on.
Excellent. You play hockey or cricket or soccer or football?
I don't.
Do you stand on your hands?
I don't.
Do you swim?
I do, I swim.
You speak Hungarian?
I'm learning Chinese.
Okay. Okay, look, there you are. And he got him wrong. Very timely.
It's not going as well as I hoped.
No, I.
Wushi, Laushi, Daushwe, Sheng, Ireland.
Okay, I can go on, I think.
That's great.
Good afternoon, ladies and gentlemen. If you'd be kind enough to take your seat, I'd be very grateful. Thank you. So good afternoon. My name is John O'Halloran. I'm head of the School of Biological Earth and Environmental Sciences. I'm a zoologist, so I know I'm among friends this afternoon. If you haven't missed the green flag on the middle of the campus, please make sure you note it. We're very proud of it. It's the first green flag campus in the world, and we're number 2 in green metrics, so you're in a sustainable university. Where we've saved over €1 million on measures of sustainability. So there is money to be made as well as saved. So you're very welcome, and apologies for running a little bit later, but I know you've been told about this because two of the sessions overran earlier, which means that I'm going to keep very strict time for 2 reasons. One is to respect your time, but also so that there is an opportunity for you to move between the sessions as you so wish. So I'm not going to stay any longer. I'm going to introduce our first speaker, who I've had the privilege of meeting before at our law examination boards, and that's Professor Colin Reid. And Colin is a colleague has been very generous to UCC as well as his presence here today. He joined University of Dundee as professor in 1991, has been professor of law there since 1995. And some of you will know, of course, that he's widely written, particularly on his book on nature conservation and law, which his 3rd edition is now issued, and his recent work on Climate Change Act 2009 in Scotland. He's currently working on a Research Council funded project on the privatisation of biodiversity. Sends shiver down the spine like somebody like me, but let's see what comes of that. And a whole range of other activities. In January 2014, he was appointed as chair of the Legislation, Regulation and Guidance Group of the Partnership for Action Against Wildlife Crime in Scotland, which brings together the police, land managers, conservationists and the Scottish Government. He's also interested in ecosystem services and has made a whole range of contributions. And finally, he takes great pride from the fact that he still plays hockey and still plays cricket, and he's going to loft a few balls in here this afternoon. So ladies and gentlemen, please give a warm UCC welcome to Professor Colin Reid. Colin, thank you.
Good afternoon, ladies and gentlemen. A real pleasure to be back in Cork. I've got the session just after lunch, so there are 2 options for that. One is to be very dull and boring and to let you sleep. The other is to try and make you work by doing a very quick canter through lots of ideas, lots of things to go, and I'm afraid I've chosen the second. So this is going to be a very quick run through what is in essence a 2-year research project that I've been working on in Dundee with a colleague, Dr. Untitled. Start off with bad news in terms of biodiversity, that basically we're failing. All the targets that have been set nationally, internationally for biodiversity have been missed. And this is despite the development of stronger and stronger measures for direct regulation, using an approach that's based primarily on designating sites and species, prohibiting acts that are harmful, controlling uses of land to conserve habitat, imposing penalties for breaches. It's just not working. And we look at the wider context. We see that in other bits of environmental law, there's been an exploration of other approaches, other ways of dealing with things beyond the traditional command and control approach. You've got the various nudging mechanisms using environmental taxes, reporting and disclosure duties, eco-labelling and so on, trying to encourage people to more environmental measures. And you've got the various trading and offset schemes, trying to use a private sector approach, a market approach, to help the environment, particularly in the areas of greenhouse gases and carbon. So we've got this diversity of approaches in those areas. Now, within biodiversity, it's not all direct regulation. There are a range of other approaches used. We've got, in various countries, various forms of management agreements, whereby landowners are, in effect, paid for environmentally friendly farming, for looking after their land in an environmentally good way. The agri-environment schemes through the Common Agricultural Policy and so on, putting an onus on at least a certain level of environmental management stewardship of the land with higher rates for more active involvement. And under the Natura 2000 scheme, under the Environmental Liability Directive, you have got the idea of a certain amount of trading, that if you damage biodiversity in one place, you trade that off because compensatory measures have to be taken. If you allow development of a Natura site, you have to compensate for that in some ways, which is in a sense equivalent to an offsetting mechanism. But what we're seeing around the world is an interest in applying a diverse range of approaches to biodiversity ideas. And we've got here a range of things I want to run through very quickly before talking about a number of the pervasive issues, the challenges which exist in trying to make use of these ideas more widely. Biodiversity offsets, payment for ecosystem services, conservation covenants, tradable permits, taxes, and impact fees. What these share, which is why I came up with the title Privatisation of Biodiversity, it's the sort of thing research councils like. Catchy title helps to get you the money, so you've got to think of an exciting name for it. Is that there are ways of engaging the private sector, as opposed to conservation being something that's done by the government, a state agency, and other people. You're involving a wider range of actors. You're trying to get in some element of market approaches often into these schemes. So, I'm going to run quickly through each of these, then look at some of the pervasive challenges. Biodiversity offsetting first. What's it about? Well, the basic idea is that you can allow development that causes harm to biodiversity in one place to go ahead, so long as compensating benefits are provided elsewhere. You are ensuring there's no net loss to biodiversity across a wider area, rather than just trying to preserve things on the one particular site. And this allows an element of flexibility. You're not sterilising a particular site, you're allowing development there to go ahead. It also means that the private sector ends up paying for conservation. The polluter is paying. The developer, the development that is causing biodiversity harm is paying for the restoration, the enhancement of habitats elsewhere to make up for this. Bringing in the idea of offsets, familiar idea from the greenhouse gases and so on. But if you're going to go forward with an offsetting idea, you've got to think about the options. You've got to think about the design for the precise scheme. Is it going to be a like-for-like offset, or are you going to allow a different sort of habitat to be protected? If you destroy, if you drain a bit of bog, are you going to have to create equivalent wetland, or are you going to allow a coastal site to be done, a forest site to be done, so long as there's still no net loss? How local is the offset going to be? Is it acceptable ecologically? It may make sense to attach your offset to something miles away, because you are then part of a wider habitat, a wider ecosystem. But for the people locally, they've then lost their local issue. So the issue of locality is important. What's the role going to be of the developer? Are they simply simply paying for it, and then it's up to somebody else to deliver the offset? Or is the developer going to have a continuing obligation into the future, decades into the future, if you're talking about woodland, to make sure that the offset is in fact provided, that it is delivering? Do you do the offsets on an individual basis, site by site, or do you amalgamate schemes together, which can develop into a biobanking scheme, such as what they have in Australia, whereby people running conservation sites run them as on a large scale, allowing you the benefits of large-scale conservation, but then the developer who needs so many credits for the habitat they're destroying pays for a share of the wide element. You buy a credit. If you're developing, you owe so many credits because you're destroying this much biodiversity. You make up for it by buying credits in a site that's already up and running, a long-scale scheme that's going. So design issues that you've got to think about. I'll come back to some of the wider issues, the wider challenges in that sort of approach. Another approach is payment for ecosystem services. That big idea in conservation, in other areas, thinking about ecosystem services. What are they? Well, the idea is that the natural environment, to the extent that we have in these islands, any environment that is truly natural, the natural environment isn't just sitting there doing nothing. It's actually providing us with a whole range of incredibly valuable, useful services. You've got some of them on the screen there. All of these are actually very valuable to society. It would cost a fortune to replace any of these. If the bees don't pollinate our crops, how much is it going to cost students in their summers to go around with little paintbrushes pollinating every plant? So, paying for ecosystem services, what do you try and do? You try to provide a vehicle whereby the beneficiaries, the people who are benefiting from these services, pay the providers. people who are providing the service. And this provides an incentive for the services to be maintained. Leaving some of your land in a natural condition suddenly is worthwhile because you're getting some income for it. It's saving those who are benefiting the vast cost of replacing the services they're missing. But if you're going to do this, again, you've got to think about the design of the scheme. What exactly is being paid for? What is the service that is being paid for? Who is entitled to receive the payment? And who is the person that should be paying? Can you do this on an individual basis, or do you do it on a society level as a subsidy, a general grant tax approach, whereby society as a whole is, as the beneficiary, is paying for it? So if you're going down PES schemes, paying for ecosystem services, you've got to think about the details. Another approach, conservation covenants, also known as easements, burdens, servitudes, something that operates in the realm of private property law, not public law regulation, private law of property. The landowner agrees enduring restrictions on the use of land, restrictions on the use of land that are going to bind his, her, their successors and titles. So you're actually an obligation on the land. This allows long-term conservation to be established not through a state agency, but privately, between the private landowner, developer, conservation group, whoever it is that wants to do it. But traditionally, land law hasn't liked this. Traditionally, land law in the Anglo-American systems has said, well, enduring restrictions on land are a bad idea unless they're for very identifiable neighbours. They don't like this idea of tying up land in general terms a long time into the future. So you're going to have to legislate to introduce these. Where the potential is, it allows landowners and conservation groups to agree long-term conservation based on their own priorities, what they think is important in the areas they think is important, rather than everything being dictated by the official conservation body. And one of these covenants, easements, it provides a mechanism for payments from the private sector. If you're paying to provide a service, how do you guarantee the service is going to be provided in the future? Well, you have one of these conservation covenants, conservation easements to guarantee it. It also provides a mechanism for offsetting. How do you guarantee that the new area of woodland is going to continue as a bit of woodland providing biodiversity into the future? You tie it up with a conservation covenant. The landowner can no longer get rid of, isn't able to develop the land as a matter of private law. But if you're going to use covenants, you've got to think again about the details of the design. How freely available are they going to be? Is it going to be a limited scheme, controlled one, or is it going to be very open? Are we going to be happy that various bits of land are going to be subject to these long-lasting obligations that are going to last decades, maybe centuries into the future? How long are they going to last? You've got to balance permanence and flexibility. The whole idea is that you're committing the land to a certain use, you're making sure it can't be developed, but things change. You want to have some flexibility to respond to climate change, to respond to changing circumstances, changing political, public priorities, social priorities, and so you need to have some element of response. How freely available are these going to be? If you make these available, anybody can make one of these. You have to think a lot more about the detailed regulation, the controls on them. If you limit them to certain approved bodies and so on, to a certain extent you can take things on trust because they're subject to public scrutiny mechanisms and so on, so you don't have to build those in as an alternative. Duration of the obligation, variation and discharge. Can the parties agree in 20 years' time to change things? Can somebody else override it in future? How are you going to make sure this is enforced? Again, if you're talking about a conservation covenant for woodland, you're talking about 50, 60, 160 years into the future. You're trying to make sure that this service is provided and so on. You've got to try and think of mechanisms that will achieve that. Other approaches. Tradable permits. Something you can borrow from some other areas of law. You could identify an area of habitat, a distinct habitat that's present in an area. You could say, right, we don't need to protect all of this, but we need to make sure 80% of it is still there. So we'll allow 20% to be developed, What do we do? Well, allocate development rights to the landowners and allow them to trade between themselves. If somebody wants to keep their land as it is, they can sell their spare development rights to somebody else. Therefore, by keeping the land as it is, they're actually getting some benefit from it. They get some income from keeping the land as it is. But obviously there are concerns about this because you're expressly saying, we identify this habitat as important, but we're allowing you to destroy 20% of it, so it seems a bit odd as a conservation measure to be setting up a scheme that destroys the habitat. And as with all tradable permit schemes, you've got huge worries about what the initial allocation mechanism is going to be. Are you going to auction them, grandfathering rights, all sorts of issues that have cropped up in greenhouse gas and other areas. Or you can use the tax system. You can use the tax system more to further biodiversity and so on. It can be a way of encouraging careful stewardship, tax benefits for those who do the right thing, discouraging harm, tax penalties, disincentives for doing the harm thing. And this can be used as a mechanism for ecosystem services, for payment for ecosystem services, collecting money through the tax system from wider society that is benefiting, using benefits in the tax system to help those who are providing the ecosystem service that is valuable. Advantages that you can fit this into existing administration. Every country has a tax scheme that, I was going to say every country has a tax scheme that works. Now I was thinking of Greece and other places. Most countries have tax schemes that work, administrations are already there, but fitting with other financial and other policies can be a problem. And finally, in terms of new approaches, you could think about impact fees. That if you carry out a development that causes harm to biodiversity, then you need to pay a fee for that. You're paying a levy for to make up for the harm that you are causing. That money is then dedicated to biodiversity purposes, so it's earmarked, it's kept for biodiversity purposes. But if you're going to do that, you've got to try and think about the valuation. How do you value what the scale of the fee is? How do you make sure that it is actually used for biodiversity purposes rather than disappearing into other public funds, other ways of doing things? So you've got there a very quick run through a number of different ways in which you can try to provide for biodiversity, different ways in which you can try to protect the environment, which move away from the direct regulation. They use a range of new ideas. The problem, all of those though, have a number of problems and significant issues we need to think about in terms of definition and valuation, effectiveness, physically and as a market, governance, and a very important conceptual mismatch as well. But we've got to recognise that all of these are already issues present in many of our existing policies. Because we're thinking about new mechanisms, you see these ideas as if they're new, but actually a lot of them are already under the surface. We already have to deal with them in the way we look things at already. So let's look at some of these issues. Thinking about tradable systems, market systems and so on, people obviously think about all that's happening in climate change, greenhouse gas and so on. But there's a big difference between biodiversity and greenhouse gas, in that biodiversity is what you can call non-fungible, which we can illustrate with a nice equation, which is that that does not equal that. They're not the same. You can't simply swap one sort of biodiversity for another. You're dealing with very different things. Biodiversity is site-specific. You can't, any sort of trading scheme, any sort of payment scheme, you've got to try and think, well, how do we value things? Can we value things? Do we accept equivalence between very different elements of the natural world? And various elements to this. Location. There are physical limitations. The geology, the climate, water resources all affect what you can do. You cannot develop a bit of coastline and establish the same habitat 20 miles inland. It just doesn't work. They're different. You've got to think about locations. A major constraint on any tradability, equivalence, and so on that's going on. You've got to think about timing. Habitat takes a long time to mature before it delivers the benefit. So are you going to give somebody the credit today for planting a woodland that's only going to deliver biodiversity benefits in 50 years' time? Or rather, that may deliver benefits in 50 years' time. How are you going to the time scale again? I've already mentioned issues of enforcement. Coherence. Biodiversity policies have got to be coherent. You've got to protect all the features a species needs to flourish throughout its lifetime. Time for habitat to mature. You need a landscape catchment scale approach to link habitats. And if you're moving to a more market-based scheme, rather than one that's controlled by state conservation authorities, you've got to think about coherence. You don't want everybody rushing to replace a variety of habitats with the one habitat that's cheap and easy to produce. You get an imbalance there, and the whole system gets skewed in a dangerous way. So you've got to try and think how you're going to make the system work together. You're dealing with dynamic environments. Circumstances change. That not all that many, within living memory, most of that was sea. It's in the Lake District in England. That's been built up over the years. In decades to come, the river will come back over this side of the water, and all the marshland, all the salt marsh will be on the other side of the estuary. So circumstances change, climate change, other things. Arrangements you make today, enduring arrangements you make today, may not make sense in decades' time. Social, economic priorities change. What makes sense today to protect absolutely may not make sense into the future. To the extent you're dealing with a sort of a market, a private sector approach, you've got to think also about the effectiveness of the market. What is actually being traded or paid for? If you're paying people for ecosystem services, if you're doing a biodiversity offset, what's actually being traded? What are you paying for? It's not just giving up the rights of a landowner. You've got to try and work out what legal rights, who has legal rights in ecosystem services. Our property law just doesn't think that way. We're not used to ecosystem services being something that can be owned, that can be traded. And if you're talking about ecosystem services, do you deal with them singly or as a bundle? An active peat bog. It's a carbon sink. It's important for water management. It's important for biodiversity. So does that mean you get paid 3 times? Or you only get paid once because you're only doing the one management operation? You've got to work out what exactly are you paying for, who's paying for it. Who should receive payment? Well, the landowner, yeah, okay, but a lot of land, there are tenants on it, long-term tenants into the future, areas of common land, common grazing and such like. Who is the beneficiary there? How does it affect with who's the provider? How does it affect with their rights? And if you're talking about buying and selling rights, verification and security. How do you know what you're paying for? How do you guarantee what you're paying for today and into the future? Additionality as well. If you're talking about these things, if you're paying people, well, you shouldn't be paying them for doing what they should be doing. In any case, you're paying for them to do something extra, for doing something more than business as usual. But that's quite difficult with changing policies at government level, and the clean development mechanism under Kyoto Protocol has shown the difficulties of establishing what is genuinely additional, what's genuinely new and different. Government schemes, if you're going to go onto this sort of approach, this more varied, more diverse approach, you've got to think how they're going to be governed. You need transparency, you need accountability at an individual level and across schemes as a whole. What's going to be the role of the public in terms of participation and accountability? Integration. If you're going to have this more fragmented, this more diverse approach, how's it going to fit together with other policies, other plans? Well, it's a more flexible approach. Rather than everything being done through the State Conservation Agency, it's more flexible and maybe easier to fit with agri-environment schemes, planning, management agreements, business plans and so on. But that diversity also creates problems with coherence to make sure you do have all the areas linked up, you do have all the stages in a species life cycle looked after. So you get the benefit of flexibility, you lose coherence. But there are also ethical concerns in all of this. The idea of privatization is something that causes problems. In some ways, it's very positive, because biodiversity becomes part of the economic system, which in practice dominates society. As we were hearing earlier this morning, you've got to speak the language of the economists, because the economists are the ones who are in charge of so much. By bringing biodiversity into the system, by giving it an economic value, you're allowing it to be part of the game, which in reality is the only game in town. On the other hand, hugely negative view from an ethical point of view. You're transforming biodiversity, our common heritage, into a commodity. It's a fundamentally misconceived view of our relationship with nature, according to some people. It's just fundamentally wrong to think of biodiversity, of nature, in economic terms. And this is an issue that's been raised in other areas, particularly in relation to water. You have comments such as the Water Framework Directive. Water is not a commercial product like any other, but a heritage which must be protected, defended, and treated as such. Against that, things like the Dublin Statement, water has an economic value in all its competing uses. Past failure to recognise the economic value of water has led to wasteful and environmentally damaging use of the resource. If it's not seen as having an economic value, it gets ignored, it doesn't get treated seriously enough. So, we've got interest in moving to other approaches to biodiversity conservation. The existing method isn't working particularly well. Can we do better by doing different things? The new mechanisms allow for more flexible and positive responses. They're creating incentives for conservation action of various sorts. They might better fit individual needs rather than a rigid approach through designation and absolute protection. But in this, there's a danger of fragmentation, a lack of coherence, problems of tying things together. If we're going to think about these, there are clearly challenges to be met, but they can be tackled to some extent. I think that there's a danger here that because people see the challenges, they think because we can't solve them all, because we can't get the perfect solution, we won't do anything. Whereas in fact, this isn't a system that can take over from the traditional approach. But there are opportunities there. The current system isn't working in so many areas. Maybe by using elements of this in a limited and a controlled way, we might be able to improve on the current situation in a way that gives us more experience, that allows us to experiment for the long-term future. Thank you very much. There's just details of the project.
Thank you very much, Colin, for a tremendous review and insight. Have we time for some questions? Yes, sir.
I'd just like to know what your views are on who will be the independent arbitrator that will decide on what's to be measured and whether the compensatory measure is sufficient.
That's one of the issues that's being talked about. In England, where this is being driven most strongly, the idea is that it's tied into the planning system and it would be the planning authority. But there are various options being talked about. You have certified valuers who would do it. But the whole valuation system is interesting because in England the proposal is for a very simple idea, which they say you can do in half an hour. In Australia, for some of their trading schemes, you've got to do a week's course to be a qualified valuer, and then this limited pool of people are the only ones who can do that valuation and trade-off.
Just as going on from that then, is there a danger then that if it is too localised, that the locals will say, yes, we can allow this trading, but the broader community going farther may say, no, this is really valuable and we want to hold on to it?
Yeah,
how will that be catered for?
Again, that's one of the challenges, to try to sort out how much do you leave it in the hands of the parties to do the initial deal, and indeed later on, could they change the deal at some stage later? How much do you involve third-party interest? How much do you say everything's got to be approved by some state body? When you're talking about the locals, well, they may not want to lose their little bit of woodland, even though it's no great value. And the wider, when you go out from the town to the county or the wider area, it should be developed. Trying to sort all those things out, there are challenges. But in a sense, there are challenges that we already have in a planning system. We already have in looking at designation of sites and when we allow exceptions to be made.
Thank you.
Any further questions? Yes, thank you.
First, not much questions, but comments. In my judgment, it says it's not possible to, for example, it wasn't possible to compensate for limestone pavements because it's non-renewable habitat. And most priority habitats, most, not all, would be unrenewable in a lifetime.
Yep.
That's the first point. And community gain, we've had a little bit of community gain in Ireland at various planning things. It has been 100% misused.
Yep.
So I don't agree with any consequence
Again, the proposals in England where this is most developed, the acceptance is that there are certain things you would just never touch. You wouldn't, this would be not for the Natura sites, not for the designated sites, it's for the ones below there. And the argument from the people pushing this forward is that although planning policy says that you should always have regard to biodiversity, you should always be doing something, not just protecting the top sites. The reality is that unless you have a strongly designated site, nobody thinks about biodiversity. It just gets ignored altogether. So that any sort of benefit you'd get to make up for what you're losing would be a gain on the present situation. It took me some time to accept that. I mean, some of the real zealots for this, I thought, I mean, they're just private market, private market zealots, which some of them are. But there's another group of people who are just so fed up at seeing biodiversity always being ignored, all the time being ignored, that any gain they think would be a benefit.
What is involved here is that it's not a designated habitat under Natura, it is ignored.
Yeah, and the idea is that, well, if you did add some sort of offsetting system, you'd calculate that.
We don't just Boole it.
Yeah, well, you calculate that if you're going to Boole this, that you've got to provide something alternative. But at the end, it relies on the valuation, the verification of what's going on. It relies on the determination, the willingness of the various authorities to make sure that it is carried through.
That's the signal to stop question. Okay?
Yeah, thank you. Thank you for those comments. Yeah.
Karin Dubsky of Coastwatch. I think this could potentially be really interesting for floodplain management. And I'm just wondering whether you have any examples. So at the moment what we have is we've had a lot of extra flooding and erosion in Ireland, and a lot of farmers are increasing the height of their estuarine banks, and therefore you are likely to have more flooding of towns. Just like to explore, if farmers were to get some top-up payment, which would be biodiversity and flood relief, who would be paying for it? The city, which isn't going to be flooded, or?
That can be done. I mean, in New York State, it's not flooding, it's water quality. In New York State, the water from New York comes from the mountains, and they pay the farmers there not to use certain chemicals and so on, so that they therefore don't have to, certain treatments they don't have to put to the water that cost them a lot of money. Some of the mineral water companies are exploring this as well. They're wanting to protect their catchment, so they don't have to treat the water and so on, save money that way.
Okay. Okay, one very, very last question about this. We need to keep...
Sorry. Yeah. Thanks. Is your approach not in conflict with Article 6.3 of the Habitats Directive, where it's only a plan or project that's for the benefit of the SSE that can be applied for?
Well, the idea would be that these don't apply to, the...
Is it not subverting the objective of the directive?
Well, yeah, because the idea is that you're still, if you look, even in the Natura Directive, they've got offsetting in it, and that if you can allow even a Natura site to be developed, so long as you're taking compensatory...
Is it not in the absence of alternatives, though, that you can only get down that road?
Yeah, but yes, I mean, that's at the very top end of the sites that are most protected. Why this is being talked about is for sites that are sort of everyday run-of-the-mill sites. You're not destroying a site that's particularly valuable. It's just the constant everyday erosion that's happening across the countryside all over Europe. That's where you're trying to get. You're trying to get some gain, some recognition of that, of what you're losing.
Okay, I think we stop.
Sorry, is it not a better approach to just allow proposals that are for the benefit of the SSE?
There are lots of approaches that might be better. The problem is where the proponents of this come from is that the current system just isn't recognising them at all, and that this, as a stronger, more concrete approach, might work better.
Okay, we're leaving it there. No, sorry. Apologies.
Happy to speak to you.
Happy to speak to coffee, but I mean, I have to try and control the time. Thank you for that, your patience. Thank you very, very much. And thank you, Colin, for a very stimulating presentation. And there will always be opportunity for coffee. I know I hate cutting off good, exciting discussion. Our next speaker is the convener of the meeting, and inspired many years ago. In fact, this is the 12th meeting that Owen and his colleagues in the College or Faculty of Law have organised, and it's Dr. Owen McIntyre, who's very familiar to all of you here. He's a senior lecturer in our own university here in the Faculty of Law. His principal areas of interest are in environmental law, with particular research focus on water, both international and nationally. He's a member of the Scientific Committee of the European Environment Agency, chair of the IUCN World Commission on Environmental Law, an honorary lecturer at UNESCO, panel member of Project Complaints Mechanism of the European Bank for Reconstruction and Development, and earlier this year, the Minister for Agriculture, Simon Coveney, appointed him to the Statutory Aquaculture Licence Appeals Board. He's learning Chinese. He's told me that he's not going to speak his presentation in Chinese this afternoon, which was great. And Owen, we look very forward to hearing what you have to say. Thank you, Owen.
Okay, I'm not sure how to make that full page. Oh, here, I can use that. Yeah. What I want to talk about, first of all, I want to say that I have a full text paper that will be put up on the web. All our presentations and papers will be put up on the web. So it's a long argument. So for anybody who wants to look into this, if you're interested, look at it more closely. I was conscious last year at this event, for anybody who was here, that we had just received the Sweetman judgment just before our conference last year, and it wasn't on the agenda. And so I was keen that maybe I would do a paper to look at this notion of integrity, the importance of the Sweetman judgment, and do an analysis of it. Now, to do so, I have to give a little bit of background on the Habitats Directive, and on Article 6 in particular. So if you don't mind, I'm going to fly through that very, very quickly, just to give some context, and then go to look specifically at the Sweetman judgment. Now, what I want to do is, I want to look at the reasoning of the court. And I'm using and particularly their approach to legislative interpretation. And I'm using a framework set out by our own Mr. Justice Niall Fennelly in an article in the Fordham International Law Journal from 1996. And to my mind, there's a difficulty with the Sweetman judgment. We have the protagonist here, as many of you know. We have two Mr. Sweetman, but we have the Mr. Sweetman protagonist in the case here. But when I look at the judgment, I really struggle to understand how the court came to the decision that they did. And the other issue is, I wonder what the implications of that might be. And I just want to run through those very quickly with you. First of all, the Habitats Directive itself. Well, Article 3 sets down the key aims, and the key aim really is for key habitats to be maintained or improved to a favourable conservation status. Article 4 sets down the process of designation. Now, the importance of that, as has just been mentioned here, is that it employs an enclave approach, that we designate certain areas of high ecological value, and then we give those areas special protection. Article 6 is the key provision with regard to the protection of those sites, of Natura 2000 sites. Section 6.2 involves this general obligation in respect of those sites, not where there's a new plan or project planned, but generally to prevent deterioration of habitat or disturbance of species. Article 6.3, which we look at, is the process for appropriate assessment, and then Article 6.4 is the Europe exception to the a negative finding under an appropriate assessment. Article 12 and some subsequent articles deal with species protection outside of those special sites. Now, Article 6.3, I'm not going to go through it. I think people are mostly familiar with it, but the appropriate assessment is rather different to environmental impact assessment in that it's determinative of the outcome. You have to establish beyond reasonable scientific doubt that the plan or project will not adversely impact on the integrity of the site. So this notion of integrity is absolutely central. It's not defined in the directive, and it actually didn't really receive any direct judicial elaboration until the Sweetman decision from this time last year. So if we look at the process of appropriate assessment very quickly, there's 4 stages to appropriate assessment. Screening to see whether an appropriate assessment is necessary, if there are likely to be significant effects, and if there are, then they must be studied in an appropriate assessment. Stage 2, the appropriate assessment itself, to determine whether or not this will adversely affect the integrity. Stage 3, the assessment of alternative solutions, where you get a negative result from the appropriate assessment. And Stage 4, the assessment of compensatory measures. And here you're into Article 6.4, the Article 6.4 exception. As is made very, very, very clear very recently, in February of this year, in an Advocate General's opinion in a T.C. Briel's case, a Dutch case about a motorway widening project. Now, if we look into the Stage 2, the appropriate assessment itself, it breaks down into 4 steps. The gathering of all relevant information, and I have to go through these a little just to make a point, but the gathering of all relevant information, the prediction of likely impacts, the assessment of whether the impacts will have an adverse effect on the integrity of the site, the actual the determination. And then step 4, the assessment of mitigation measures. Step 1, gathering of all relevant scientific information, and these are the kinds of things you would expect to be looked at. But if we look at key structural and functional relationships creating and maintaining site integrity, 4 points down, I mean, this is ecological scientific information which is to be gathered up as part of the process. The stage 2, the prediction of likely impacts, and this has to be conducted within a structured and systemic framework, using various types of technical means of predicting the impact, different quantitative predictive models, information from similar projects, expert opinion, etc. Again, these are factual experience, scientific judgment. And then the assessment, step 3, we have these integrity criteria. And we have, under the guidance, I'm citing here from 2002 methodological guidance on the implementation of Article 6.3 and 6.4 from the Commission. And it provides this integrity of site checklist, and these are inherently ecological factors. So delays or interrupts progress with regard to conservation objectives, disrupts key factors, interferes with population balance, distribution, density of key species, vital aspects of structure and functioning of the site, area of key habitats, diversity of the site, habitat fragmentation, loss reduction of key ecological features. This is, John, I hope I can defer to you, a reasonable checklist for an ecologist to look at ecological impacts. So it's a scientific process, a technical process. Now, what do we know? Well, we have had some case law, but not directly on the concept of integrity. We've had, for example, the Vadensee case where, the standard of certainty that there would be no adverse effects on integrity was set very high. There must be no reasonable scientific doubt must remain as to the absence of such effects. So we really have to be quite certain. Commission in Portugal, which really is about the boundaries of the concept, not the concept itself. And in this case, a significantly high overall impact and a high negative impact on avifauna in particular within an SPA. The authority in that case was not entitled to authorise, was not entitled to find that this did not adversely affect the integrity of the site. And the court stressed here, and I'm going to go back to this point again, that the authority had the choice of authorising under Article 6.4. And Commission in Italy, which involved a number of successive studies. The studies lacked definitive conclusions. There were a large number of conditions, a large number of additional protection requirements. Assessments, some of the assessments were to be carried out progressively. In other words, we'll figure it all out as we go during the implementation of the project. And so it lacked complete, precise, definitive findings, etc., to remove all reasonable scientific doubt. So this has to be a conclusive, complete, definitive process. Nothing else will do. So then we move on to integrity, on to what I really want to talk about. Now, in the Sweetman decision, I know many of you are very familiar with it. One point, the N6 Outer Galway Relief Road, which many would argue in Galway is badly wanted. The 1.47, if I'm correct, 1.47 hectares of limestone pavement would be lost, would be irretrievably lost, out of a sub-area of the candidate SAC that consisted of 85 hectares of limestone pavement, and in the SA, or the candidate SAC in its entirety, there were 270 hectares of, so arguably 1.47 out of 85 or 1.47 out of 270. Now, the High Court found that a localised severe impact does not necessarily preclude a decision that the integrity of the site is not affected. It said you must focus on the integrity of the specific site. That's quite clear from Article 6.3. And they said it was not an absolutist position. So it was a question of proportionality. I find it encouraging to see the Irish High Court talking about proportionality in terms of the implementation of an EU-driven requirement. And then in respect of integrity, and the court went ahead and tried to give a definition or some form of working definition of integrity. And the key issues that came out of this were that it should be whole or complete, should have resilience and the ability to evolve, capacity for self-repair and for renewal, with minimum external support needed. Maybe not a bad stab at it, but I'd leave that to ecologists or other people to inform us on that. Now, academic studies have repeatedly shown that there are problems. There's great uncertainty with regard to integrity. One particular study in Finland showed that maybe 20% of appropriate assessments conducted there were just wrong-headed, had taken a very, very wrong approach scientifically towards integrity. but various other academic studies. The Supreme Court, when the Sweetman went to the Supreme Court, it was referred on to the Court of Justice of the European Union, uniquely. And that brings us, on to the reasoning of the court in Sweetman. And again, as I said, I'm using Fennelly's sort of categories and subcategories of legislative interpretation. And, you know, and I'm also conflating, I'll try and separate them out where it's important, but conflating the AG's opinion and the court. Now, as you would expect, if you understand the process, the AG gives a principled opinion first, and then the court gives a decision having regard to that. But the court very, very strongly supported the AG's position, and the AG's position was particularly strong, although the court was less committal in terms of the reasoning than the AG. Now, the first thing we have to look at is this notion of teleological interpretation. And the court has long used this notion of teleological interpretation, where a provision is not to be interpreted in isolation, but you must consider the wider context of the Habitats Directive or beyond the Habitats Directive of EU law. This process of teleological interpretation, you know, it appears to be used quite a lot by the court to permit judicial creativity, to ensure that the court isn't confined by the black letter of the law, if you like. And I think here that this has happened to a very considerable degree. What the court did in this teleological reasoning was they looked elsewhere in the directive and they said that the notion of integrity must be informed by the idea of favourable conservation status. The key aim to restore habitats to favourable conservation status or species to favourable conservation status, and this is the key aim under Article 2, an Article 2 objective. The only issue is that there's a definition of favourable conservation status, and it's a highly technical, scientific definition set down under Article 1E. But the court didn't really have any regard to that. Flowing on from this notion of favourable conservation status, the court said that it was necessary to maintain the site's constitutive characteristics at a favourable conservation status. And that this was an inferred conservation objective of the site, the conservation objectives of the site that are referred to in Article 6.3 that must be have regard to. The court suggested this very strongly. And they said that this was especially true regarding permanent or long-lasting loss of priority habitat types. Now, they also referred to the precautionary principle, and we'll come back to that, taking account of the precautionary principle to inform their decision-making. In many ways, I would be concerned that the precautionary principle can be used to allow the court to apply any high standard of environmental protection that they choose. There's no consideration whatsoever of the integrity checklist. Again, you know, if it's teleological. And the decision itself is really quite unclear regarding what's the position regarding permanent loss of non-priority habitat types, and also where recovery is possible. In fact, the AG makes statements to the extent that where recovery is possible almost in any way, that it's less likely or unlikely to have an adverse impact on the integrity of the site. And I think that we could have much worse positions where you had temporary loss than you would have where you have permanent loss of a very small element. And so this is a very directive decision, but I'll continue in that vein. With regard to the precautionary principle itself, now let's look at what the precautionary principle actually requires. It's thrown around by the court in a manner quite casually, you know, that this is informed by the precautionary principle, but we rarely are told what that means, how the precautionary principle has informed this decision, how it worked, how it operated. Now, we know that there's a requirement under the Habitats Directive to have rigorous regard to the precautionary principle and that it's integrated into Article 6.3. This was clearly stated in the Vadensee case, even though the precautionary principle is not mentioned in the Habitats Directive. But it wouldn't be, because it was only included in the treaty in '92 by the Maastricht Amendments, the same year as the Habitats Directive was adopted. But they say that it's indispensable to the effective implementation of the directive, indispensable to the effective implementation of the directive. So this looks like the effet utile doctrine, which is, Fennelly refers to it as the constant companion of the teleological effect, the effet utile doctrine, which is effectively a purposive approach that allows the filling of gaps, or the filling of lacunae, where there's a gap in the provisions in the legislation. We can also look at it as a contextual variant of the teleological approach. In other words, that we're looking in the broader context of EU law, looking at the treaty and taking the precautionary principle from the treaty, even though the treaty does not explain to us what the precautionary principle means. Now, we can also look at it as the guidance function of the environmental principles. And the court likes to use these environmental principles on occasion to interpret legislation really quite creatively. Whereas at the same time, and I refer to the Batati case, at the same time we know that the court will not allow these principles to be used as a grounds for review of a community measure. They're too uncertain to be used. The precautionary principle couldn't be used to challenge a community measure and to challenge its legality. But it's good enough for us to read off the page and to make up what the legislation means. And I would be very concerned about that. If it's good enough in one purpose, it really ought to be good enough in the other. But when we ask what does the precautionary principle actually require, well, it requires that we rely on best available scientific knowledge. Any articulation of the precautionary principle and a commission paper, a ComDoc from 2000 on the precautionary principle insists again and again and again that you must use the best available scientific knowledge, and there's no evidence that the court attempted to tie this to best available scientific knowledge. And of course, the ComDoc is also full of the language of proportionality, that the precautionary principle must be applied in a manner that is proportionate. There's no evidence that the court took cognizance of that. The next issue is that this really looks like a policy decision. Now, a policy decision is something that the court would never admit to engaging in a pure policy decision, but, you know, the court has never let the letter of the law get in the way of a good outcome. But, you know, this notion of a policy decision going beyond the usual teleological approach, although it would be hard to go beyond it, and going beyond the effet utile doctrine of filling lacunae. But here we have what might be an extreme purposive version of the teleological approach. The AG in particular, on several occasions, talks about death by 1,000 cuts. This is a purposive approach, saying if we don't find that any loss, any permanent loss of a priority habitat type, we will suffer this death by 1,000 cuts. So this is policy. Now, the AG did insist, in her opinion, that the death by 1,000 cuts argument has no role in determining integrity. Has no role. Now, in the same breath, she goes on and she then criticises the contrary view put forward in the proceedings, the view of the An Bord Pleanála of the local authorities in the UK. She criticises it, and she criticises it though it's based closely on literal wording. That was something she was critical of. That the argument put forward, the contrary argument, was based closely on the literal wording of the directive, and she criticises that argument on the basis that it doesn't take account of the death by 1,000 cuts argument. So I don't know how you can, in the same breath, say it had no role in determining integrity. This is a policy decision. It's a directive policy decision. The court also implicitly appears to accept this line of reasoning. Now, the problem with that is, if we're worried about death by 1,000 cuts, what about cumulative assessment? Cumulative assessment is expressly included in Article 6.3, where you're supposed to take account of any other related project. And the 2002 Commission methodological guidance on Article 6.3 and 6.4 places tremendous emphasis on cumulative assessment and sets out a methodology for cumulative assessment. So this wasn't really something that the AG and implicitly the court needed to worry about. There's also a comparative linguistic analysis, and this is where I think we start to get into the really truly bizarre, where the comparative linguistic analysis, and this is something the court very often engages in as part of the teleological approach. The AG looked at English, French, Italian, German and Dutch versions of the concept of integrity, of the legal meaning, or the literal meaning of the concept. Now we're back to literal. Literal's okay. Of the literal meaning of the concept of integrity, and she came up that this meant essential unity, wholeness, soundness of constitutive characteristics. Once you see these words, you know where this is going. Now, the Advocate General, this particular paragraph 54, was approved expressly by the court, and this does not allow for any de minimis consideration, for any minimal loss, whatever its ecological impacts may be. They may be non-existent. But it doesn't allow that, taking that particular approach, and this was given tremendous weight by the AG and approved by the court. So what about relevant scientific information? Article 4, for example, on designation requires that we have a regard to relevant scientific information. There was no literal focus on that. Favourable conservation status. In Article 1A, as I mentioned, this is a very technical scientific concept. There was no literal focus on that. And the court itself, in its decision, in paragraph 40, actually said that the determination in regard to Article 6.3 had to be in the light of the best scientific knowledge in the field, but I could find no evidence of them having considered what that would mean. Now, I owe this slide to our chair, not playing up to the chair here, but I do. We looked at this issue in a transdisciplinary conversation within the university some time ago, and I squeezed John's slides down into one. But essentially, the interdependent elements of ecological systems and habitats: structure, composition, and function. And this appears to be the language of the ecologist and what an ecological assessment would involve. And John gave me a quote or a formulation of ecological integrity from Parrish et al. I don't know if that's a he or a she or what their background is, but it was good enough for you, John. And it's the ability of an ecological system to support and maintain a community of organisms that has a species composition, diversity, and functional organisation comparable to those of natural habitats within a region, which actually is not that terribly different from the High Court's attempt. Now, why would I have a difficulty with this? What are the policy implications of it going forward? Well, what we basically have is a statement, a directive statement, and that says that any permanent loss of priority habitat, it simply means, ergo, that is an adverse effect on the integrity. Any permanent loss of priority habitat type. That's what the court appears to say. Now, I'm wondering, is this a question of the court overreaching itself? Has it gone too far in this? It's a judicially creative approach that's very strict, inflexible, simplistic, crude, policy-driven, rather than a scientifically sound, proportionate, and achievable integrity standard. Now, what does that mean? What are the implications of that? Well, there's a failure here to have regard to the scientific complexity of the issue, to actually to rely on an ecological assessment, on scientific nuance, on structure, composition, and function. This is set out in really considerable detail in the 2002 methodological guidance. And the court had absolutely no regard to this. It rather a linguistic or policy analysis rather than have regard to what the scientific implications of this might be, or to have regard to what the trial court found the scientific implications might be, more importantly. So completely ignoring ecosystem dynamics. Now, the two key lessons or warnings I would have for this is, first of all, we have to consider the breadth of the European exception, which is potentially very, very, very wide. Now, it's nominally narrow in priority habitat types, but actually, how many negative opinions have been received from the Commission? The court itself points out, or the AG points out, one negative opinion from the Commission. It's not that big a control. Now, my problem with that is that competent authorities within member states have tended to prefer not to use it for local political reasons, etc. To try and work through, looking at putting real effort to engage in mitigation and all the rest of it, but to try and meet the standards set down in Article 6.3. I would be concerned that they would more or less proceed straight to 6.4. Of course, you have to go through 6.3, but with no real effort. To, from the beginning, plan to go to 6.4. And so 6.4 could become a matter of course, while you've gone through the motions of 6.3 without seriously engaging in how that project could be delivered differently, or that plan could be delivered differently in an alternative way, or seriously investing time and effort in mitigation. And the other warning, just to finish up, is the danger of legislative reform in this area. We've been here before. For people who know the history of European nature conservation law, look at the experience of the Wild Birds Directive. The reason that SPAs were brought forward from the Habitats Directive and put into Article 6 are now protected under Article 6 of the Habitats Directive, and therefore covered by the exception in Article 6.4, was because of an overzealous, an over-rigorous, and an over-creative, possibly, but an over-ambitious interpretation of the provisions of the Wild Birds Directive in cases such as the Santona Marshes case, the Lappelbank case, and the Leibrook Dykes case. In those cases, I would suggest the court won the battle, but they lost the war. And is there a danger of this happening again? Thank you.
Thank you, Owen, and we have some time for questions. Questions? Yes, thank you. We get a microphone maybe, please? Yes, lady. Thank you very much. While the microphone is going, if you are tweeting, hashtag ENVUCC2014 for your tweets.
Thank you very much. Avian Cawley, Scott Cawley. I'm an ecologist. I found that very interesting, and there's a lot of food for thought there. I'm not 100% sure I'd agree with everything you say, but I'm not going to challenge you here without going away to think about it carefully. Just one comment I wanted to make is on the guidelines, the European guidance that you referenced there. I'm not sure that most of the ecological community would view them as best available scientific, approach. Those guidelines, I believe they're actually date from 2000, so they're now 14 years old. We've come a long way since then. We've learnt a lot about appropriate assessment and about ecology. So I think I'd just be cautious about treating those, and I wouldn't necessarily view if the court didn't use them as their guidance, I wouldn't necessarily view that as a negative.
There are two sets of guidance. There's guidance on implementation from 2000 and there's methodological guidance from 2002. In fact, it's published November 2001, but the publication date is 2002. And I, just in case we're talking about two different documents.
We're talking about the same double set of documents. In any case, they're at least 10 years old now, so it's still the same point.
Yeah, and I take that on board. And it's disappointing that they're that old. You would hope that this is something that would be reviewed at least every 5 years. This is an area of science, as I understand it, that's moving along very quickly, that our understanding of ecosystem dynamics is becoming so much more sophisticated, so much more complex. We know an awful lot more about what we don't know, etc. And again, in that regard, I have no problem with the precautionary principle, but I would like to see it tied to scientific uncertainty. I would like to see somebody say, this is the state of science, this is what we don't know, this is why we're using the precautionary principle. So it's not really a problem with the result. The problem is how they got there.
Yeah, there are elements definitely that I would agree with about how this might be applied. The ruling was a very specific case, a very specific habitat type in a very specific circumstance. And unfortunately, that probably will be applied by many working in the profession in the area. It will be applied broadly across loads of different situations, which it may not apply to.
But the court doesn't make it clear that it's for a very specific case.
Yeah,
if you understand me, I mean, it's written in a directive sense. I'm using Rachel's term from earlier on, but it's written in a directive sense.
Great, thank you. Another question to that gentleman, and then we'll have to go to Mr. Sweeten. I will let it run on a little bit because if people want to come in for the next presentation, they should be here. So we'll just give a little bit of questions. Thank you, sir.
Just a minute, yeah. Michael Hoy again. Sorry. I'd just like to put it into perspective. The directive is a 92/43 directive. The case 127 of 02 is 10 years later. And Peter's case there is probably 10 years later again. So I'm saying that the court's position is quite justified, and particularly in the context of case 127 of 02. And I'd like to just draw your attention to the last paragraph of case 127 of 02. And this is for the people that are interested in public participation and what I classify as EIA review. And it says, where a national court is called on to ascertain the lawfulness of an authorisation for a plan or project within the meaning of Article 6.3 of Directive 92/43, it can determine whether the limits on the discretion of the competent national authorities set by that provision has been complied with. So that's EIA review in the context of compliance with Articles 4 to 11. Even though it has not been transposed into the legal order of the member state concerned, despite the expiry of the time limit laid down for that purpose. So I'm just emphasising the ECJ ruled that we were entitled to this type of EIA review, and it just hasn't been picked up on. Thank you.
Thank you. Any comment? No?
I'm not sure that's really directly relevant.
Okay. Do you want to make a response to that particular?
I can explain that. I can understand your frustration, and I think with my frustration for 25 years to have proper public participation and access to justice. That's exactly what it is.
Thank you, sir. Mr. Sweetman, then this gentleman here, and then we'll close it if that's okay. Thank you.
Firstly,
just your mic is on the way, so we'll wait for you. Thank you.
Firstly, I'd like to thank Owen for the great compliment he paid to my lawyers. They obviously did a better job than the other side did. And actually, I have to be honest about it, I think it was the Commission's barrister that scored all the points. He was a Maltese gentleman. I thought he was singularly brilliant. I think he scored the points rather than anybody else. And I thought that was right. Basically, I agree with everything you said. surprisingly. The only thing, I have another case currently going through the courts relevant to some little points that will tie in a few things, particularly the status of a priority habitat which has been left out of the designation or left out of the boundaries, is more to the point of that. That's going through the courts at the moment. The only thing I think you didn't mention, which I would particularly mention, and I'm going to ask you a straight question afterwards, the word in the Advocate General's opinion, the word I liked most was her assessment of Article 6.2, basically capable of having an effect, based on the translations again. Now, this only affects, this actual translation really only affects Ireland and England, because she found it different everywhere. Have you any comment to make on where we go there? I'll challenge you to bench there, but that's the only way I'll get an answer. And then I'll ask you the question.
No, I didn't focus on that aspect of it, to be perfectly fair.
Have you looked at it, though?
I have. I know that.
What do you think of it?
I'd have to go back and look at it.
Okay, fair enough. Now, I ask you a straight question. I'm involved on the side of a developer on a case, believe it or not. I look at Rachel thinking, Rachel and I might be on the same side. And it's a very big development. It takes up 29 hectares of SAC, right? And it's going to be the first case in Ireland. It's going directly. It's going to 6-4. Now, the question here is, there's two alternatives, and in the consultation, the board were very bold, I think, because you go to consultation, put to the board, and you pay your fee. You expect an answer. Well, they didn't get one. They came back with the question. They came back and gave two alternatives, which was the question was put to them. Do you go down? The question being, there's two alternatives. One, and I think Owen's going to agree to this one, that you go straight into 6-4. If you're taking away 29 hectares of habitat, the only way you can do this is 6-4. Now, do you make the application directly, including 6-4, including the compensatory measures and everything else, and including your Europe?
No, you have to have gone through 6.3. You have to have gone through the appropriate assessment and had a negative result.
Yeah, but we know. This is not clear now. Hang on, come back. We know we're going to have a negative result because it's, under my judgment, it can be nothing else. So, do we have two hearings, or how do you think it should work?
Do you have two?
There's an oral hearing. It's a strategic infrastructure development. It's not. It's actually a state development. It's infrastructure. Do we have to go through a hearing to the board for the board to find that under 6.3 it can't give permission? And see, my argument would be, if you make an application to the board, right, and only going as far as 6.3, basically, under Irish law, the board can make a choice of three decisions. They can either grant, refuse, or modify. They can't, when it comes to that, in a way, start a new process over again. And you're saying, if we go in under 6.3, we're told, yes, it's going to have a significant effect, we know that, and now what you do next? It's going to take a long time, we have to go back and...
But we'll be here all afternoon if we don't stop soon. Can I ask you, is there a question? And just a response?
The question's there.
Yeah, that's great. Thank you. Thank you very much.
Perhaps Rachel has an answer to it.
Yeah, we'll hear Rachel's presentation. I'm not trying to be rude.
Rachel and I agree on most law, actually.
Good. Okay. So can we just go for... Mrs. Sweden, have you got a final question? And I'm just going to pass over.
How do we equate it to a two-stage process? That's what the board is advocating.
Do please, Reid.
Just a very small, I don't know if it's really answering your question, but I think notwithstanding the fact that you kind of know it's going to have an adverse effect on the integrity of the site, I still think it's helpful to have a full assessment of all those impacts when it's coming to perhaps looking at, are there going to be less damaging alternatives that should be approved instead? So perhaps that fast-track approach to 6.4 might avoid a proper assessment of all the impacts and looking at whether there may be other less damaging alternatives.
The answer coming back to that is an EIS, the EIS, shall contain all the likely significant effects, both direct and indirect, therefore should include the compensatory measures.
Okay, I'm going to stop it there if that's okay, please, and I'm going to take one last question because we are. Thank you. I'm not trying to cut people off, but we are, and we'll come to Rachel. One final question. Thank you for your patience.
Sorry, Tom Flynn, barrister's my name. Just a very good analysis, Owen, of the Sweetman decision, without wishing to sound too sycophantic. But my problem with it is, I think you touched on it, is there doesn't seem to be any provision for a de minimis consideration in it, which really doesn't make a lot of sense. And I agree with you that it's probably the high water mark of a teleological propulsive approach, which we've seen from the CJEU in the past. And I think you might be correct as well in saying it may backfire in pushing more into the 6.4 process. The only point I'd make about that is just operating that in practice, going into the 6.4 Europe within the current system as a matter of practice is very, very difficult and will have, depending on your position, make life very difficult for developers. Now, whether you think that's a good thing or a bad thing. But it strikes me that no more than kind of the previous examples of the Court of Justice in overreaching themselves, I'm thinking really of van der Walle here, again, a similar decision, pushing really the limits of the definition of waste and a very purposive. That had to be cleaned up by way of legislative amendment, and I'm suspecting, perhaps you might indicate, particularly the absence of a de minimis application, unless the court reverses itself or clarifies itself, we may be looking at a legislative amendment really to sort that problem out.
Okay, thank you. You're going to kill me as your chairman, so thank you. Thank you. Could I just move on if that's okay? So thank you for all those contributions to very valuable. Our final speaker, who we've already heard some words from, is Ms. Rachel Minch. She's a partner in Philip Lynn Lee Solicitors, Dublin, where she specialises in environmental planning and public law litigation. She's also chairperson of the Irish Environmental Law Association, Graduate University, Cambridge, on the board of the EPA, and likes printmaking in her spare time. So very welcome, Rachel, to the podium. Thank you very much, and look forward to hearing what you have to say. Thank you.
I thought I'd throw in the printmaking there, seeing as I haven't published as widely and lectured as widely as the other people here, just to see how that works. Okay, perfect. I know we're a little bit short on time, and Owen has touched on some of the points that I was going to discuss, so I'll try and move through those relatively quickly. I'm going to sort of take a bit of a step back in relation to the analysis of the directives and look at the interaction between assessment under the Habitats and EIA directives, and specifically to look at how they are distinct and how they compare in certain key areas. Now, when you look at them, there's obviously certain superficial similarities. For example, an assessment has to be carried out before consent is given. An assessment is required of the impacts. I'm just going to look at projects here and not get into the SCA directive. An assessment of projects on the environment or certain elements of the environment, and also the trigger for assessments is ostensibly the same, that the project must be likely to have significant effects. And in the early phase of implementation, many practitioners and also the Irish legislature effectively equated EIA and AA. So the Habitats regulations provided that an EIA shall be an appropriate AA for the purposes of the regulations. This was then struck down in Commission versus Ireland, where the ECJ held that an EIA cannot replace the procedures under Article 6.3 and 6.4 of the directive. And one of the reasons for that, the first distinction, is that EIA is only required for listed projects under the directive, so it's mandatory, as I'm sure you probably know all of this already, but mandatory for projects under Annex 1, and then mandatory for projects under Annex 2, whereas screening shows that those types of projects are likely to have a significant effect on the environment. And there's no territorial limitation as such in relation to the application of the directive. Under the Habitats Directive, an EIA will be required for any type of plan or project that's likely to have significant effects on a European site. There's no list of plans or projects in the directive that need to be subject to an AA, and there's not even a definition of what a project is for the purposes of the directive, and it's been held to apply to a wide variety of projects, concerts, fishing, I think even sort of ferry routes, types of ferries you're using, can all amount to a project for the purposes of the directive, or a plan, arguably, as well. In relation to exemptions then, the EIA directive provides for a number of exemptions from the EIA process, so member states can decide on a case-by-case basis to exempt certain defence projects. In the revised EIA directive, which is coming through, the latest version, which was published, I think, just early last month, which I understand is the one that is going to be formally adopted, now also provides for exemptions for civil emergencies on the basis that the EIA process may have adverse effects on the environment, where I think presumably works need to be carried out quickly. Projects adopted by legislation, provided that they satisfy, the legislative process satisfies the requirements of the EIA directive, are also, or the objectives of the directive rather, are also exempt. and the UK Supreme Court has recently upheld the government's decision to use a hybrid bill process through Parliament to get through the high-speed rail link in reliance on this particular exemption. And then there's a general exemption in relation to exceptional cases. Under the Habitats Directive, however, the only exemption is if the plan or project is directly connected with or necessary to the management of the site. And not only that the plan or project needs to be a specifically tailored plan or programme in relation to a specific site, and generic plans and programmes for conservation management can't rely on that exemption. In relation to procedures, the EIA Directive is all about procedures. It's described in detail through about 12 various articles. The directive has been reviewed already on several occasions, and as I indicate, there's a further directive coming through which is going to elaborate further on the procedural requirements that are necessary. So, for example, there is now going to provision for the type of information that a developer is going to need to furnish when a competent authority is deciding whether or not a project needs EIA. There are revisions to the factors to be assessed, which is relevant, I'll come to later on. At the moment, one of the things that needs to be assessed under Article 3 is impacts on fauna and flora. That's now going to be amended to biodiversity, with specific attention to impacts on habitats and species protected under the Habitats and Bird Directives. Provisions in relation to the quality of EIS reports and expertise of competent authorities. Time limits, including time limits for public participation. Provisions in relation to conflicts of interest, where the proponent and the competent authority are the same body. Integration, which I'll come to later on. Monitoring, unfortunately, there was in the original directive a proposal that where there was, after consent was given, it was shown that there were going to be significant adverse effects on the environment, that there were actually adverse effects, that remedial measures would need to be taken. That's been dropped. In contrast, then, the Habitats Directive, we've just got these two subparagraphs with no detail in relation to how the appropriate assessment procedure is to be carried out. And notwithstanding, as indicate that the directive was adopted some 20 years ago now, and I think that 20% of environmental cases relate to infringements of the Habitats Directive, I'm not aware of any efforts to review or to amend the directive, perhaps to take account of some of these judgments and difficulties that are being encountered. The Commission published a study just at the end of last year evaluating the application of Article 6.3 and containing suggestions in relation to how the permitting procedure could be improved, and identified 10 substantive areas in where there are ongoing shortcomings in relation to its implementation. But the Commission is of the view, I think, that these can be addressed through improved practices and isn't proposing any amendments to Article 6.3 and 6.4 as I'm aware. So turning then just to look at the screening test, I think they're different, notwithstanding that the same language is used, likely to have significant effect under both directives. The test that is applied does appear to be different. So under the EIA directive, you just need to look at whether environmental features are likely to be affected to justify requiring EIA, whereas under the Habitats Directive, if there's a mere probability or a risk that the project might have significant effects, or if, which is the normal language now being used in legislation, if there is doubt or it cannot be excluded based on objective evidence that there will be significant effects, then an appropriate assessment is required. So I think a more stringent test there under the Habitats Directive. And as alluded to, I think by Mr. Sweetman, the Attorney General picked up on that in the opinion in the Sweetman case, noting that the expression used in other language versions is weaker, and that the normal understanding of likely to have a significant effect, which would seem to suggest that you need to establish a degree of probability before something would need to be the subject of an AA. The question that needs to be asked is simply whether the project is capable of having an effect, and it was in that sense that the English likely to should be understood under the directive. In relation to the vexed question of screening and mitigation measures, Yvonne tells me there's some guidance floating around now where the Commission is saying that measures can now be taken into account at the screening stage for AA. I haven't been able to put my hand on anything like that. I spent some time looking at it, but as far as I know, certainly the Commission's position is that you can't have regard to mitigation measures when screening a project for appropriate assessment, on the basis that the developer may have a very different view as to what an effective mitigation measure is in comparison to other stakeholders, and the most objective way to look at whether something needs an AA is to look at the project without considering the mitigation measures. There are, however, UK court decisions, I think, both in the EIA and AA field, which say that you can have regard to them when screening, provided that, I think, the language is, their nature, availability and effectiveness are already plainly established and plainly uncontroversial. And in relation to the EIA directive, the draft, the revised EIA directive, which I'll just refer to from here on in rather than draft every time, suggests to me that mitigation measures can be taken into account when screening for EIA, and this is because of new Article 4.5, which requires competent authorities to provide reasons now for their screening decisions, and in relation to negative screening decisions, where proposed by the developer, state any feature of the project and or measures envisaged to avoid or prevent what might otherwise have been significant adverse effects on the environment. So that suggests to me implicitly that you can have regard to mitigation measures in screening for EIA. Very briefly, just in relation to publication, the EIA directive always provided that screening decisions had to be made publicly available. The European Court in Mellor said then that you also need to give reasons if requested for a negative screening decision. That's now going to be affirmed in the revisions to the EIA directive. There's no explicit obligation to do so under the AA directive, but the reasoning of the European Court, I think, would clearly apply by analogy that you need to give decisions and reasons for your screening decision. We have a funny anomaly here, though, in that the Irish implementing legislation only requires the competent authority to give reasons for a positive screening decision, whereas it's really when there's a negative decision that I think the reasons are really crucial, because then you're cutting the project out from the AA process or the appropriate assessment process. In relation to what must be studied then, see a very important distinction under EIA, you're looking at likely significant effects on the environment as a whole, and as defined in Article 3, which I'm sure you're familiar with and which is going to be updated now to refer to things like biodiversity, climate change, risk of accidents and the like. Whereas under the Habitats Directive, the assessment has a much narrower focus, and you're looking at the implications of the project on the site in view of its conservation objectives as specified in the designation. And you should hopefully, though I think I understand, being an ecologist, that there will be more information for you to look at when you're coming to propose the project, whereas in an EIA situation where a European site isn't involved, there may be very little baseline data or information as to what might be on the site, which will need to be looked at and assessed. In relation to cumulative effects then, under EIA, when you're screening or carrying out the EIA, you only need to look at the cumulative effects of the project with other projects. Whereas under the Habitats Directive, you need to look at cumulative effects of projects along with other projects, but also plans. And in relation to the issue of upcoming projects, or projects that haven't already been carried out, the revised EIA directive is now limiting that to other existing and or approved projects. There was an issue as to what extent you may need to also look at projects that are perhaps in the ether or just at application stage. The directive certainly seems to now be limiting it to ones that have already received permission, whereas under the current guidance in the Habitats Directive, you need to look at completed, approved and actually proposed plans and projects, whatever that means. So again, probably a wider analysis of cumulative effects needed under the Habitats Directive. The assessment of cumulative effects was identified by the Commission in its study at the end of last year as being one of the key deficiencies in assessment processes being carried out throughout the Member States, with I think 60% of those surveyed saying that failure to assess cumulative impacts was often a problem, and going up to 90% where, if you included those who said it was sometimes a problem. In relation to the quality of the information, then this was also touched on by Owen. I think there are different standards applicable under each directive, which is maybe a little bit awkward, particularly if you're going to be carrying out assessments or an EIA and AA at the same time, to say, oh, we don't need to have as decent information on this impact, but more information in relation to the other. But in any event, the standard in the EIA directive suggests that you just need to compile your information having regard to current knowledge and methods of assessment insofar as it's reasonable to ask the developer to provide, whereas under the Habitats Directive, having regard to the reasoned Badensay and Sweetman judgments, there's a very stringent test in relation to the quality of the information that's needed. So it needs to be based on the best scientific knowledge in the field, and under the Sweetman judgment, the appropriate assessment can have no lacuna, must be complete, precise and definitive, or contain complete, precise, definitive findings capable of removing all reasonable scientific doubt in relation to the impacts of the project on the site. There are some interesting revisions coming up in the new EIA directive, notwithstanding that they have been watered down from that which was originally proposed by the Commission. EIA reports must be prepared now by competent experts, and the competent authority must have or have access to sufficient expertise to examine it. I think, sorry, am I? Oh, right. That's good. Grand. No, you're grand. And I think, in fact, that's particularly probably an issue in relation to appropriate assessment, where a lot of authorities are having to become involved now in the AA process with no ecological experience or expertise available to it. And that was actually also something referred to in the Commission report. But there does seem to be an increased emphasis on the quality of the information and arguably, closer convergence in relation to the requirements under both directives in that respect as well. Oh, and up to date was another interesting one as well, particularly where sometimes these procedures can end up taking 4 years or something by the time the EIS has gone in and a decision is made. So there's an express requirement there that the information has to be up to date when the decision is made. Consultation, I won't go into this too much. I think there's been other discussion in relation to this, but obviously it's mandatory and central to the EIA directive. There's many ways in which the public is involved, be it through publication of decisions on screening, involvement of the public obviously through the EIA process, publication of decisions, access to review procedures. Other member states who are likely to be significantly affected also have to be consulted. The Habitats Directive is silent on all of this and simply states that public consultation shall be carried out if the member state considers that it's appropriate. And I suppose you can kind of see the reasoning behind that in that due to the breadth of plans and projects that are potentially covered by the Habitats Directive, arguably you don't need to be bringing in the public every time there's maybe trimming or cutting of hedge or the like through the process. But the reality is that AA is often grafted onto procedures which already have public consultation in them. How am I doing for time? Okay. In relation to whether the assessment has to be written, I think there are ongoing proceedings in the Irish courts in relation to the extent of the competent authority's obligation to record assessments. There's no explicit requirement for it to do so, but in the Commission in Ireland case, the European Court effectively held there was, and that the obligation to take into consideration the information gathered during the course of the process shouldn't be presumed to be sufficient for the purposes of compliance with the directive. Article 3 imposes a substantive obligation on the competent authority to carry out an investigation and an assessment of the impacts of the project on the environment. So that led to legislative amendment here along the lines of the court judgment, and I think the interesting point will be that whilst the legislation provides that competent authorities can, in complying with this obligation, rely on and adopt its inspectors' reports, to what extent must their decisions contain an assessment of the effects where they depart in whole or in part from those reports? And I'll just flag there's going to be a more robust provision in the revised directive in relation to the decision having to contain reasoned conclusions on the significant effects on the environment of the project. In relation to habitats, then, very similar. The guidance says you need an AA report, and the court decisions have said you need also a reasoned decision on conclusions of the appropriate assessment. The one I think we're probably all familiar with, obviously the key distinction in relation to the two directives is that the EIA directive is essentially procedural, whereas the Habitats Directive contains substantive obligations, and a competent authority can't approve a plan or project if it's going to adversely affect the integrity of the site unless Article 6.4 applies, and this standard has now been adopted in the Sweetman case. There was a question as to whether there may be an evolution under the EIA directive in relation to outcomes, and the Commission's proposal, the Commission's proposal for a revised EIA directive as originally drafted said that if, as a result of the EIA process, it appeared that there were going to be significant adverse effects on the environment, the competent authority had to consider whether to go back to the developer and require it to submit a revised EIS and revised proposals and further mitigation measures. So a more proactive approach there was being proposed by the Commission. That's ultimately been dropped from the latest draft. There are maybe some other indications that the competent authority does need to engage in a more substantive way, perhaps with the findings, in that, for example, its decision has to include a summary of the results of the consultations and information gathered and how those results have been incorporated or otherwise addressed. But I don't think that really means that if someone raises a concern about impact on the environment, you have to say how you've how you're going to remedy that as such. I don't think it goes so far as to say that. In relation to alternatives then, they come in at very different stages in the process. Under the EIA Directive, they come in at the start, but all the developer has to do is provide description. Now it's going to be of the reasonable alternatives that he's looked at, having regard to its effects on the environment, whereas under the Habitats Directive, damaging projects can't proceed unless there is no alternative and there are imperative reasons of overriding public interest.